What's going on, guys? This is Coach Keem. So I wanted to go over this particular article that I found dealing with a consumer that was awarded punitive damages against a collection company for some violations of state law. We're going to go over this because it may be able to help some of you guys in your situation. Maybe you're dealing with a collection company or something like that, and you might need this information, right? So let's just get into it. So it says $225,000 punitive damages were upheld where creditor repeatedly contacted consumer after being notified of attorney representation. So this consumer was represented by an attorney. So it says earlier this year, a district court of the Middle District of Florida upheld a jury award of $225,000 in punitive damages in a debt collection case finding the defendant's conduct reprehensible, right? So first off, what are punitive damages, right? So if we look at the definition here of punitive damages, it says punitive damages are considered punishment and are typically awarded at a court's discretion when the defendant's behavior is found to be especially harmful. So this is what she was, or this consumer was awarded punitive damages for, because again, like it says right here, the defendant's conduct was reprehensible, right? And it says based on the physical harm caused to the plaintiff, the defendant's indifference or reckless disregard of the harm it caused to the plaintiff's financial vulnerability, and the defendant's repeated actions, right? So it says in Medley versus Dish Network, the plaintiff signed up for the defendant's satellite TV service, but later became unable to pay for the subscription. The defendant offered a pause program that allowed the plaintiff to suspend service for up to 9 months at a cost of $5 per month. All right. It says, which the plaintiff accepted. It says, ultimately, the plaintiff filed for Chapter 7 bankruptcy protection, listed the defendant as an unsecured creditor, and obtained a discharge of her debt, right? So she went through bankruptcy. She included this account in the bankruptcy, is supposed to be discharged, right? Right. It says the plaintiff's lawyer sent 2 faxes to the defendant providing notice that the plaintiff was represented by counsel, right? It says after receiving notice of representation, the defendant sent 5 billing notifications to the plaintiff and made 6 telephone calls attempting to collect on the $5 monthly payment, right? So the fact that the plaintiff had their lawyer send them 2 faxes, right, letting them know that they was represented by counsel, they violated this particular section, right? It says the plaintiff filed suit against the defendant alleging, among other things, violation of subsection 559.7218 of the Florida Consumer Collection Practices Act, or the FCCPA, which is this right here. Oh, no, not that. Well, let's just go over this though, because this is a link that I'm going to drop in the description, but this is on the CFPB website, right? And it says, what should I do when a debt collector contacts me? Now, the good thing about this website, among all of the information that it gives you, is that it gives you some sample letters, right? As a matter of fact, it gives you 5. One of them being, I want the debt collector to only contact me through my lawyer, right? So you can use this kind of letter if you're represented by a lawyer, and send this to the debt collector, right? So it's probably not going to pull it up because it'll probably pull up the PDF, but I'm going to drop this in the description. You can use the link, go here and use these debt collection letters, right? You can also send them a cease and desist letter, like this third one that says, I want the debt collector to stop contacting me, right? And then there's a whole bunch of other ones that you can use as well. So that's a great resource. I'm a heavy advocate and proponent of the CFPB and their resources. As far as a regulatory authority, they don't always do what they're supposed to do when you file your CFPB complaints. That's why it's always best to just take these credit bureaus, creditors, and collection companies straight to court for violations of state law, right, or federal law, like this consumer did in this instance. right? So it says, which makes it unlawful for a debt collector to communicate with a debtor if the debt collector knows that the debtor is represented by an attorney with respect to such debt and has knowledge of or can readily ascertain such attorney's name and address. Now that has to do with, again, the Florida state law, right? 559.72, right? And it was subsection 18, right? It says, in collecting consumer debt, no person shall. Now, when they use the term person, they really mean like a corporation, like a collection company, right? In this instance, it's talking about collection of debt. So it would only apply to collection companies. But that could mean under like the Fair Credit Reporting Act, person means like a furnisher or a lender or a creditor. It can mean a collector or a collection company, right? Or just a corporation in general, right? So when you see that term, it's not necessarily talking about a person, right? It's a corporation. But it says, in collecting consumer debt, no person shall. And if we come down to 18, it says, communicate with a debtor if the person knows that the debtor is represented by an attorney with respect to such debt and has knowledge of or can readily ascertain such attorney's name and address, unless the debtor's attorney fails to respond within 30 days to a communication from the person, unless the debtor's attorney consents to a debtor's communication with the debtor, or unless the debtor initiates the communication, right? So that's the criteria, but they actually broke that law. So it says the FCCPA claim was ultimately tried before a jury, which awarded the plaintiff $1,000 in statutory damages, $8,750 in actual damages for emotional distress, and $225,000 in punitive damages. And they're going to talk about the emotional distress and how it actually equates to physical harm, right? So if you're going through these things, it's very important to know that and to stress that in your suit or your case, right? And before I get any further, this is not legal advice, right? This is just for educational purposes. I should have said that in the beginning, but um, got well, right? So it says the defendant filed a motion to reduce the punitive damages award on constitutionality grounds, which the court uh, denied. The most important factor in determining whether a punitive damages award is constitutional is the reprehensibility of the defendant's conduct, which the court found was satisfied based on the physical harm caused, the defendant's indifference or reckless disregard to the harm, the plaintiff's financial vulnerability, and the defendant's repeated actions. That's the same thing they stated above, but they're going to get into it, right? It says, first, the court found that emotional distress suffered by the plaintiff, confusion, worry over her credit, and heart racing was a form of physical harm that could support punitive damages. Again, that's important to understand because you want to take note of that, because if you're going through this, you want to stress this in your suit, right? In your complaint, in your lawsuit, right? Throughout the court case, right? You want to stress that, look, I was confused, I was worried about my credit, that thing gave me anxiety. I had, I had to go to the doctor to get, checkups and stuff like that because I was just worried and stressed, XYZ, right? This is physical harm, right? That can support punitive damages, and this is where you're going to get your real awards from, or the money that you're really trying to, sue for, right? It says, second, the court found that the evidence supporting a finding of indifference to or reckless disregard of the health and safety of others, right? It says, specifically, defendant repeatedly contacted the plaintiff despite his knowledge that the plaintiff was represented by counsel and that she had filed for bankruptcy due to her financial troubles. Further, the defendant testified that approximately 50,000 of its consumers file bankruptcy each year, meaning that the defendant routinely deals with individuals who are financially vulnerable. Against this backdrop, the court found that the lack of employee training regarding the requirements of the FCCPA or debt collection actions that are precluded under the law, and the systemic failure to document attorney representation demonstrates an indifference to the plaintiff and others in her position who are at a low point in their lives, and are thus vulnerable, or most vulnerable, excuse me. It says this same evidence also supported findings that the plaintiff was financially vulnerable and that the defendant had engaged in repeated collection activity. Again, they wasn't supposed to contact her after they were made aware that she was represented by an attorney. and they kept doing that. Right. So it says the court also rejected the defendant's argument concerning the disparity between the actual damages award of $8,750 and the award of $225,000 in punitive damages. So they was trying to say, oh, look, it's excessive, right? It says the defendant argued that the 26-to-1 ratio is excessive and should be at most 4-to-1. The court rejected this argument, noting that the analysis cannot be reduced to a simple mathematical formula. Specifically, the court explained that the purpose behind punitive damages is retribution and deterrence, and that the wealth of the defendant must be considered, right? Given the large size of the customer base of the defendant, the court found that the $225,000 award was consistent with those purposes without being grossly excessive, right? So again, you gotta take these people to court when they violate your rights, right? Don't keep going back and forth with them, sending them letters, sending communications with them. This is why it's important to understand the law, right? Or at least have a rudimentary understanding of the law, right? Debt collection law, right? The FDCPA, whether it's the federal law or the law in your state, the Fair Credit Reporting Act, whether that's the federal law or the similar law in your state. And because these are the main corporations that we're going after, right? The credit bureaus and collection companies. You can also go after the original creditors too under the Truth in Lending Act, right? Sometimes, right? TILA, also under the Fair Credit Reporting Act too. If you're disputing properly, you make them aware of things, right? So you just have to pay attention to those things. So I hope that this video helped give you some clarity and some understanding on the dispute process and what it entails. If you have any questions, just reach out to me. I left some descriptions in the link below, or I left some links in the description below. You can also check out my free DIY credit repair training video where I teach you how to use artificial intelligence like ChatGPT, Credit Coach DIY, which is my software that analyzes your credit report for errors for you, chooses the specific dispute reason that you need to get that account removed, and drafts the dispute letter automatically for you, right? So, if you want any further assistance and any training, just make sure that you click the link in the description below, and I see you guys on the other side. All right, peace.